Hello everyone, welcome to the daily news analysis. Today we are starting a new section in our YouTube channel that will analyze the news daily. Every day you have to read the newspaper because newspaper is one of the most important elements of your law entrance examination preparation. It not only covers your general knowledge in current affairs but also your legal reasoning, because most of the passages, most of the articles in the news are regarding the latest legal developments that you might find as a passage in your CLAT paper and other law entrance examination papers. In addition to that, we also cover the English language. If you have this habit of reading newspaper daily, that really enhances your vocabulary, the sentence creation, the structure of sentences, and it covers essentially three areas: your current affairs general knowledge, your English language, and your legal reasoning. So newspaper is the most one of the most important elements for your law entrance examinations. So starting today, we'll cover all the relevant news, legal news, current affairs news, as well as all the relevant news that you require for your CLAT and other law entrance examinations. So let's begin with the news for 14th December 2022. Just 1 second. Okay. So coming to the first news, it's about the Assam Accord, and you must be aware about the Citizenship Amendment Act that was very much in news some time back. There was so much controversy about it. There were so many people protesting the Citizenship Amendment Act, and the also the NCR and CAA. These were the two hot topics some time back. Still, the controversy is ongoing. Let's see what the news is about. A constitution bench. What is a constitution bench? A constitution bench is one where five judges sit in the Supreme Court. That is known as the constitution bench. On Tuesday, listed for January 10, 2023, a series of long pending petitions challenging Section 6A of the Citizenship Act 1955. So the important thing here to understand is there is a section 6A of what? Of Citizenship Amendment Act 1955. What does it do? It allows citizenship to illegal immigrants, mostly from neighboring Bangladesh, who entered Assam before March 1971. So all the immigrants who entered Assam from Bangladesh before March 1971, Section 6 provides citizenship to those people. So that is something that has been challenged. These petitions had been lying dormant since the court had gone ahead and monitored the publication of the final Assam NRC list in August 2019, and the government had enacted the Citizenship Amendment Act. So the government had enacted the Citizenship Amendment Act for giving the citizenship. People they are preparing the national register. So that has been challenged here. Section 6A was a special provision inserted into the Act in furtherance of a memorandum of settlement called Assam Accord. So see, the title of this news is Assam Accord. Constitution Bench lists citizenship case for 10th January 2023. So, in furtherance of a memorandum of settlement that was called Assam Accord, signed on 15th August 1985. That time, Rajiv Gandhi was the Prime Minister in 1985, by then Rajiv Gandhi government, with leaders of the Assam movement. Why? To preserve and protect Assamese culture, heritage, linguistic, and social identity. The accord came after a 6-year agitation by the All Assam Students Union to identify and deport illegal immigrants. So, of course, Assam as a state, if people from Bangladesh, people from other places are coming to Assam, it is diluting their culture, it is diluting their linguistic heritage, social identity. So there were a lot of agitations regarding that. So that was what we call Assam Accord. So under Section 6A, foreigners who had entered Assam before January 1, 1966 and been ordinarily resident in the state would have all the rights and obligations of citizens. Those who had entered the state between January 1966 and March 1971 would have the same rights and obligations, except they would not be able to vote for 10 years. So they will be like citizens only, Just that they cannot vote for 10 years, that is the difference. Petitions were filed challenging the discriminatory nature of Section 6A in granting citizenship to immigrants, illegal ones at that. The petitioners, including Assam Public Works and others, argued that the special provision was in violation of Article 6 of the Constitution that fixed the cutoff date for granting citizenship to immigrants at July 1948. So we have in the Constitution of India, Article 5 to Article 11 talks about citizenship. So we have Article 6 in the Constitution of India, and the petitioners are arguing that the cutoff date for granting citizenship to immigrants, that has been set as July 1948. One of the petitioners, Assam, Sanmilita Mahasangha, a Guwahati-based civil society organization, had sought the updation of the National Register for Citizens for Assam on the basis of 1951 NRC and not on the electoral rules of March 1971. As you know, that census happens every 11 years. So this has sought that what was the NRC that was there in 1951, that should be taken as the base and not the electoral rolls of 1971. In 2015, a three-judge bench of the court had referred the case to a constitution bench. On Tuesday, appearing before the five-judge bench led by Chief Justice Chandrachud, please, very important, every law aspirant, every law student should at least know who is the Chief Justice of India. So, Justice D.Y. Chandrachud. So, the bench led by Justice Chandrachud, Senior Advocate Indira Jaising, said the case concerned people who have been citizens for a period of 40 years. Whether people who have acquired citizenship can now be denied citizenship, that is the question, and this question should be heard as a preliminary issue. Ms. Jai Singh, for one of the parties, urged the court. Senior advocate Dushyant Dave, also for a party, said the focus of the case was the validity, whether Section 6A is valid or not, and that should be decided first. Mr. Dave also highlighted questions raised about Section 3 of the 1955 Act concerning children born in India to parents, one of whom is an Indian and the other a foreigner. The court asked the lawyers to meet and finalize the issues and present them before the bench on January 10th. So this is the news. It's not a very new news if you will see. The only new thing here is that a date has been fixed for January 10, 2023. This is an ongoing news. You must have come across this news several times regarding Citizenship Amendment Act, regarding Assam Accord. So same things have been argued over and over again, that what should be the cutoff date, what should be the baseline. All that has been discussed several times. But this time, the Constitution Bench has listed the citizenship case for January 10, which is regarding the Assam Accord. And the question here is, as Indira Jaising has put, that whether people who have acquired citizenship can now be denied citizenship. This question should be heard as a preliminary issue. So this was about the first news. Let's move on. Next news is regarding the Kerala. So the Kerala passes bills to replace governor as head of universities. See, universities, if there is a head of universities, it is preferred that the head should be someone from academics, someone who teaches, someone who is related to teaching. Having governor as the head of the university, that is something that has been seen as a question mark. So the Kerala Assembly has passed two university law amendment bills to replace the governor as the chancellor of 14 state universities. The legislation, subject to governor's assent, will enable the state government to appoint academicians or persons of eminence in various fields of knowledge as chancellors in all state universities, except one exception has been made here: National University of Advanced Legal Studies and Kerala Kalamandalam. So Kerala Kalamandalam and National University of Advanced Legal Studies, these are the two exceptions where governor can be the head of the university. Other than that, for 14 state universities, the proposal has been made to replace the governors. The opposition, United Democratic Front, staged a walkout in protest against the refusal to accept the amendments the party proposed to the bill. It also accused the Left Democratic Front of attempting to erode the autonomy of universities and turn them into Marxist centers. The opposition sprung a surprise during the discussion as it moved a motion to appoint a chancellor for the 14 universities instead of separate chancellors for each. So they proposed one chancellor for 14 universities instead of having separate chancellors for each university. That came as a surprise. Then, Law Minister P. Rajiv proposed the inclusion of the speakers on the panel that would be chaired by the Chief Minister and also have the Leader of Opposition as a member. The Minister refused to accept other proposals that were made by the opposition. Meanwhile, a division bench. Now, what is a division bench? A division bench is where two judges are sitting. A division bench of the Kerala High Court stayed a single judge's verdict upholding the action of Governor Arif Muhammad Khan in his capacity as Chancellor in appointing Caesar Thomas, Senior Joint Director, Directorate of Technical Education, as Vice Chancellor in charge of APJ Abdul Kalam Technological University. So essentially, the Kerala Assembly has passed two university law amendment bills to replace the governor. The governor of a state is acting as the chancellor of the universities. That scenario should change, and instead of a governor, there should be an academician or a person of eminence. That is essentially the main crux of this news. Then the next news is again about Supreme Court. Supreme Court to decide if Sena faction dispute needs to be referred to larger seven-judge bench. So a five-judge bench of the Supreme Court on Tuesday said it will consider on January 10. See, January 10 is coming again here also. In this also, we had the first news was also that this will be listed for January 10. And one more thing is happening on January 10, which is that a five-judge bench of the Supreme Court on Tuesday said it will consider on January 10 whether the political battle between Uddhav Thackeray and Maharashtra Chief Minister Eknath Shinde over the real Shiv Sena needs to be referred to a larger bench of seven judges. On August 23, a three-judge bench of the court had referred the dispute to a constitution bench of five judges. So, please understand this, whenever a matter is being taken up by a bench of judges, so if one judge has ruled it, it can be overruled by a division bench of two judges. If two judges have ruled it, it can be overruled by three-judge bench, or similarly five-judge, seven-judge. So, a higher judge bench can overrule a judgment given by a lower judge bench. So that's how it happens. So five judge has already delivered the judgment. Now whether seven judge bench should consider it, that is the question here. On Tuesday, the five judge bench led by Chief Justice of India D.Y. Chandrachud heard preliminary submissions made by both factions, who urged the court to refer the case to larger bench. The lawyers argued that the three-judge bench had realized important constitutional questions relating to interpretation of 10th schedule. What is 10th schedule? 10th schedule is anti-defection. Now, what is anti-defection? See, whenever a political leader he gets elected from one political party, after getting elected, if he changes the party, then he is committing defection and it is not allowed. Or if the mandate has been given by the political party to act in a certain way but he acts in a different way, suppose the political party says that everybody has to vote on this matter but he refrains from voting, or political party says refrain from voting but he votes on the matter, so not acting as per the guidance of the political party from which he has been elected is also considered as defection. So it is given under the 10th schedule of the Constitution of India, defection of the Constitution pertaining to disqualification. He can be disqualified from being a member if he commits a defection. So, pertaining to disqualification as well as the powers of the Speaker and the Governor and the power of judicial review. What is judicial review? Judicial review is the power of the judiciary to review the laws made by the legislature. If Parliament has made a law but it is not in line with the Constitution, the Supreme Court has the power to strike off that law. This power is called judicial review. It had highlighted gaps in the court's 2016 five-judge constitution bench judgment in the Nabam Rabia case, which had related to the power of the Speaker, Deputy Speaker to initiate disqualifications proceedings, where proceedings for his own removal from the office had been initiated. The 2016 judgment had held that a speaker, deputy speaker, should refrain from deciding the disqualification of MLAs for defection under the 10th schedule of the Indian Constitution, while he himself was facing the prospect of removal. So see, that is how one should refrain when you yourself are facing the prospect of removal. Then how can you decide? So the 2016 judgment was meant as a safeguard against a speaker using the disqualification proceedings of legislature for his own political ends. A speaker, under the threat of losing his position, may choose to disqualify the MLAs to alter the composition of the House in his favor, thus securing his position at their cost. The bench, while had referred the matter to referred the Maharashtra case to a constitutional bench in August, had framed 10 questions of law. So this is the issue that after hearing the submissions, both the factions urged the court to refer the case to a larger bench. The five judge bench already decided the matter in 2016, but there are some reservations regarding that. So now the matter is being asked to refer to a 7 judge bench, to a larger bench. That is the issue here. Bilkis Bano, this case was very much in news in the recent past when the 11 men who were sentenced to life imprisonment for gang raping Bilkis Bano were released earlier. So the case is again back in news after so many years. So let's see what this news is about. Supreme Court judges recuses. Recuses means the Supreme Court judge recuses herself. That means she will not hear that case because of could be any reason. Whenever a person recuses himself or herself, that means he or she does not want to be involved with that case due to maybe conflict of interest or any other reason. So a Supreme Court judge recuses herself that I will not listen this case, I will not be part of this case from hearing Bilkis Bano's petition. Supreme Court judge, which judge recuses? Bela M. Trivedi on Tuesday recused herself from hearing a writ petition filed by Bilkis Bano against a Gujarat government decision to prematurely release 11 men sentenced to life imprisonment for gang raping her and murdering her family members during the 2002 riots. As you know that there were riots in Gujarat back in 2002. That is a very politically charged incident that comes up again and again in the political discussions, especially against the Gujarat government, against the Narendra Modi government as well. So that time 11 men were sentenced to life imprisonment for gang raping her, for killing her family members. However, they have been released prematurely. So now this news has come up again for discussion. Justice Ajay Rastogi, who led the bench, said the writ petition would be written to the Chief Justice of India to be listed before another bench of the top court because she has recused herself. Now it will be referred to another bench. Justice Trivedi hails from Gujarat. She started her judicial career in the district judiciary in 1995 and worked in different posts including the Registrar Vigilance in the High Court, Law Secretary in the Gujarat government, Central Bureau of Investigation judge, special judge, etc. She was elected as a High Court judge in February 2011. A review petition of Ms. Bano was also listed on Tuesday for a decision via circulation by a bench led by Justice Ajay Rastogi. So what is Bilkis Bano's case actually? Ms. Bano, she has sought a review of the Supreme Court judgment of May 2022 that paved the way for the Gujarat government to release the 11 convicts. She is saying that this is the violation of her fundamental rights. In her writ petition, Ms. Bano, through advocate Shobha Gupta, has argued that the early release of the convicts amounted to a violation of her fundamental right to life. She has said the remission policy of the state of Maharashtra, where the trial happened, and not Gujarat, would have governed the case. So she is saying that this is not done in the proper manner. Others, like Communist Party of India Marxist (CPIM) leader Subhashini Ali and Trinamool Congress leader Mahua Moitra, have challenged the early release of the convicts. The court had given the petitioners time to respond to a Gujarat government affidavit on the matter. The affidavit by the state of Gujarat had revealed that while the Superintendent of Police, CBI Special Crime Branch Mumbai, and the Special Judge CBI of Greater Mumbai opposed the premature release, all the authorities in the Gujarat and the Home Minister recommended their release. So some were opposing, however, the Home Ministry and the all the authorities in Gujarat recommended their release, and after their release, she's saying that there has been a violation of her fundamental right to life, and that is why this is now being challenged. So this is an important news. Bilkis Bano case is an important case because it has been in news recently. No panel formed to consider scheduled caste status for Dalit converts. Government has clarified. So the government is saying that there has not been any panel that has been formed to give the scheduled caste status for the Dalit converts, the Dalit who have converted. So the union government has not formed any commission to study granting of scheduled caste status to Dalit converts. Minister of State for Social Justice and Empowerment A. Narayan Swamy said in a written reply to the Lok Sabha. Now, whenever we are reading the news, it is very important to highlight, note down the names of these people. So, who is the Minister of State for Social Justice and Empowerment? A. Narayan Swamy. He said in a reply to the Lok Sabha on Tuesday, Mr. Narayan Swamy was responding to a question by YSRCP member Margani Bharat on whether the government had constituted a commission to study giving scheduled caste status to Dalit converts. The response came despite the Ministry of Social Justice and Empowerment on October 6 publishing a notification regarding the formation of a commission of inquiry to examine the demand for providing scheduled caste status to Dalit people of religion other than those notified in the Constitution Scheduled Caste Order 1950. While saying no to the YSRCP member, the government, however, pointed the Gazette notification on the formation of the commission. The first term of reference of the commission in the notification was outlined as follows. To examine the matter of according scheduled caste status to new persons who claim to historically have belonged to the scheduled caste but have converted to religions other than those mentioned in the presidential order issued from time to time under Article 341 of the Constitution. The matter of according scheduled caste status to Dalits who have converted to Christianity or Islam is pending in the Supreme Court. So Dalits, they already have a reservation, but the Dalits who convert to other religion, that is a matter that whether they should also be given reservation or not, or they should be given a scheduled caste status or not. So that has been discussed here. So the Dalits who have converted to Christianity, so if there is a Dalit who has converted to Christianity or who is converted to Islam, that matter is already pending with the Supreme Court, and this matter is also the government has clarified that there is no tribunal, no panel that has been formed to consider the scheduled caste status for Dalit converts. So these were some legal specific news regarding Supreme Court, regarding the government's clarification, regarding the legislations, ordinances, bills. Here is one news regarding defense, where the Chinese tried to change the LAC. What is LAC? LAC is the line of actual control. So LAC status quo, Chinese tried to change the line of actual control status quo. What is the status quo? A status quo means as it is, the thing as it is. So Rajnath Singh has said that Indian Army bravely prevented the PLA. What is okay? Let's come to that later. PLA from transgressing into our territory and compelled them to return to their post. Defense Minister tells Parliament about the clash at Yangtze. The Chinese troop unilaterally tried to alter the status quo, change the status quo on the line of actual control, where in Arunachal Pradesh, when on December 9. And the move was contested by Indian soldiers in a firm and resolute manner, Defense Minister Rajnath Singh said on Tuesday. Making a statement in both houses of parliament on the clash on Yangtze in Tawang sector, Mr. Singh said the ensuing face-off led to the physical scuffle in which the Indian Army bravely prevented the PLA. Now, what is PLA? PLA is People's Liberation Army. PLA is People's Liberation Army from transgressing into our territory and compelled them to return to their posts. So Indian Army did not let them alter the status quo. They tried it, but they failed because Indian Army retaliated. This scuffle led to injuries to a few personnel on both the sides. So there were injuries, there were no fatalities, but there were injuries. I wish to share with the House that there was no fatalities or serious casualties on our side, he said. Meanwhile, speaking to the media outside Parliament, Home Minister Amit Shah said, no one can capture an inch of land till the Narendra Modi government is in power. The BJP government will not allow any intrusion on land. We will not leave an inch of land. The bravery shown by soldiers is appreciable. They have saved our land. So the Indian army has saved our land, did not let the Chinese troops to encroach, to enter or alter the status quo at the line of actual control. Now PLA, that is the People's Liberation Army, blames India for latest face off at LAC. So this is our side of the story. Chinese are blaming Indians for whatever happened. This is the latest standoff, the latest face off that happened. The Chinese military on Tuesday blamed Indian for triggering the December 9th clash by illegally crossing the line of actual control. People's Liberation Army Senior Colonel Long Shahwa, spokesperson for the Western Theatre Command, said the Chinese military was conducting a regular patrol in the area, in the Dongzheng area, on the Chinese side of the LAC. So the Chinese are saying we were on our side. We never tried to alter the status quo. But Indians are saying that Chinese tried to alter the status quo. So there was a standoff, there was a face off, some clash happened. However, there were no fatalities. Few people were injured from both the sides, and that is what that happened. So this is the Indian side of the story. That is the Chinese side of the story. Chinese are saying that we were on our side. We never tried to cross, and Indians are saying that they tried to alter the status quo. That's why we retaliated. So that's the news about the defense. India UK FTA talks restart with Goyal Badenoch meet. So Piyush Goyal greeting his British counterpart Kemi Badenoch in New Delhi on Tuesday. So this news is about the relationship between India and UK. Who is Piyush Goyal? Piyush Goyal is the Commerce and Industry Minister. Commerce and Industry Minister Piyush Goyal. And who is the Commerce and Industry Minister in UK? It is the Kemi Badenoch. They held the sixth round of discussion on the India UK FTA. What is FTA? FTA is Free Trade Agreement. FTA is Free Trade Agreement, which had been stalled over multiple issues, including uh, reported Indian demand for greater number of student visas and political turmoil in the UK. As you know, that UK has faced a lot of setbacks, a lot of turmoil in the recent past. The Queen died, the administration changed several times. Liza Truss was there only for a short while. Then prime ministers after prime ministers came. That was a turmoil in the UK that is happening. So a lot of discussions were stalled. Ms. Betancourt, who arrived on Monday, held a round of meeting with Mr. Goyal soon after landing here and continued extensive discussion till Tuesday amidst indications that the official negotiators would meet to deliberate on the landmark trade pact on the upcoming New Year. Held a bilateral meeting with the UK Secretary of State for International Trade, Kemi Badenoch, with the sixth round of India UK FTA Free Trade Agreement negotiations on discussed how both sides can arrive at a mutually beneficial agreement to boost trade and investment ties. That is what Piyush Goyal said. The ministers asked the negotiating team to work together with an aim to iron out the differences in the spirit of mutual accommodation based on the principle of reciprocity and respect for each other's sensitivity for a balanced, mutually beneficial, fair, and equitable outcome. Stated in an official from the Minister of Commerce and Industry that described the discussion as satisfactory. So the discussion was in a positive note. It was described as a satisfactory discussion. Mr. Goyal presented flagship projects of the government such as national infrastructure pipeline, development finance institutions, and privatization of non-strategic sectors (PSUs), and urged the businesses in India and the UK to take advantage of these initiatives for economic prosperity. The trade pact ran into trouble because of the political instability in the UK when Liza Truss resigned after a brief stint of 44 days, which also jeopardized the Deepavali deadline for the trade deal that was announced by the Boris Johnson during his visit to Delhi last April. The two-day discussion therefore marks a positive turn in negotiations as the two sides came together, ending doubts over a lingering deadlock. So this was a see. First of all, whenever you are reading these news, knowing the concepts, at least knowing the important people, like now at least you know who is the Commerce and Industry Minister, Piyush Goyal. The UK counterpart is this Badenoch. So having these knowledge plus having the knowledge of what is being talked about. What is FTA? FTA is Free Trade Agreement. Why there has been a delay? Because of the political instability in the UK. So these are the important points that you have to keep in mind whenever you are reading the newspaper. That will be helpful to you. Next news, India may be first to hold satellite spectrum auction. TRAI. Now, what is TRAI? TRAI is Telecom Regulatory Authority of India. TRAI is Telecom Regulatory Authority of India. So TRAI, in discussion with experts, regulators worldwide, for suitable model, consultation paper to be floated thereafter, to recommend steps to ease process for government permissions, says Chief Vaghela. India will be the first country to auction spectrum for satellite communication, SATCOM, and it should be designed to attract investment in the sector. Telecom regulator chairman PD Vaghela said on Tuesday. Again, a very important piece of information. Who is the chairman of TRAI? PD Vaghela. PD Vaghela is the chairman of TRAI. Speaking at a Broad India Forum Summit on SATCOM, Mr. Vaghela said the Telecom Regulatory Authority of India (TRAI) would soon make recommendations to make permissions required for satellite communication from various ministries, informations and broadcasting, space and telecom seamless to enhance the ease of doing business in the sector. He also said TRAI had received a reference from the Department of Telecommunications for the spectrum required to be put to auction and associate aspects of satellite-based communication. He said, I think India will be first to handle the issue of auctioning the space-based spectrum. We are working on it. So that's what they mentioned. TRAI is yet to come up with a consultation paper on the spectrum auction as per the standard process meant for satellite communication. When asked about the status of the paper, Mr. Vaghela said that TRAI was in discussion with the experts and regulators worldwide for a suitable model and the consultation paper would be floated after those discussions are over. So TRAI has received the reference from DOT for spectrum to be put to auction and associated aspects of satellite communication. Auction should be designed to attract investment in the sector. Working on the auction model, application need permission from the Minister of Information and Broadcasting, Space and Telecom is already discussed in the passage. So India will be the first country to do so. Banks wrote off NPAs. Now, what are NPAs? NPAs are non-performing assets. So, suppose someone takes a loan from the bank, so it does not pay him back. Suppose what is a performing asset? Why the banks give loan? Banks give loan because they get interest on it. So, suppose someone has taken the loan, but not paying the interest. So, it is not performing for the bank. So if someone has taken the money, not paying interest, not returning the money, that means it is non-performing. So banks, in order to clear their balance sheet, they write off some of the NPAs, some of the non-performing assets. So banks wrote off NPAs in excess of rupees 10 lakh crore in the last 5 years, as per the finance minister. Banks have written off bad loans. So these are called bad loans. The loans once taken by an organization, by an individual and not returned, have written off bad loans worth 10 lakh 9,511 crore in the last 5 fiscal years. Finance Minister, who is Finance Minister? Nirmala Sitharaman. Why they did that? The non-performing assets, including those for which full provisioning has been made, on completion of 4 years are removed from the balance sheet of the bank concerned, Ms. Sitharaman said in a reply to the Rajya Sabha. Banks write off NPAs as part of their regular exercise to clean up their balance sheet, avail tax benefit, and optimize capital in accordance with the RBI guidelines and policy approved by their boards. As per inputs received from the RBI, scheduled commercial banks wrote off an amount of 10 lakh 9,511 crore uh, during the last 5 years, during the last 5 financial years. As borrowers continue to be liable for repayment, write-off does not benefit the borrower. That is the record is goes bad, so it does not really benefit the borrowers. So that has been made clear here. So that is the story about NPAs, and here is the last piece of news for today. Breakthrough in fusion technology. Let's see what this breakthrough is. The US researchers announced a historic nuclear fusion breakthrough that could pave the way for alternate clean energy sources. As you know that all over the world, we are gradually shifting to the cleaner forms of energy. So there is a nuclear fission that has been found that is being termed as a historic nuclear fusion breakthrough that could pave the way for the alternate clean energy sources. The Lawrence Livermore National Laboratory (LLNL) said an experiment it conducted this month produced more energy from fusion than the laser energy used to drive it. So the laser energy that has been used to drive in creating that energy, so more energy was created and less energy was used. So that is a good thing. The US Department of Energy described the achievement of fusion ignition as a major scientific breakthrough that will lead to advancements in national defense and the future of clean power. LLNL Director Dr. Kim Bodil described it as one of the most significant scientific challenges ever tackled by humanity. So this is the news about science. So we covered one news about science. We covered news from business, finance. That was regarding the NPS. We also discussed news from regarding the auctioning. When again a news regarding the international relationships. The news regarding the defense. Then the legal news. Some news regarding the Supreme Court judgments, the constitutional bench, division bench, bills, ordinance, legislations, and Citizenship Amendment Act. These were some important news for 14th of December 2022, and in the next session we'll come up with these are the important news. These are the important news. So what we are doing is we are shortlisting the important news for you, so that when you open the channel, you know that these are the important news that you have to focus on, and these are the important things that you should be aware of regarding these news, so that you do not waste time in the reading the irrelevant or the things that may not be so important for your competitive examination. So thank you so much. See you in the next session with more set of news. Till then, have a good day. Goodbye.